So the objective of my talk today is to give you an understanding, also an overview and big picture of what's happening in this market and what are the regulatory framework governing ICO in Southeast Asia. Basically, blockchain is a digitized, decentralized, distributed public ledger. It allows two parties or more to digitally transact with each other without any intermediary. And cryptocurrency is a digital or virtual currency that uses cryptography for validation and security. If I may draw an analogy, blockchain is a fundamental and underlying technology. It provides the infrastructure. It's like railway. And cryptocurrency is like a train that runs on the railway. Cryptocurrency runs on blockchain, and that's how it is. It's the source of capital for startup blockchain-based company. Securities represent asset, equity, or debt in a typical corporations. It also, for example, it's like shares, debentures, derivative, unit trust, collective investment scheme. It's regulated under existing securities laws. In this slide, I just want to show you the overview of the regulatory position in Southeast Asia, and we try to answer 4 questions. Are ICOs allowed or banned? Are token utilities or securities? Are crypto exchanges regulated? Are crypto assets or currency? Indonesia and Vietnam, the red color, is very clear that in these two countries are still currently in the negative territory. It means that they have banned ICO one way or another. And in Malaysia, there is no official ban, but what we understand is SC is taking it on a case-by-case study, on a case-by-case basis. There's no official approval so far. SC and BMM has issued a joint statement that securities law will still apply. Exchanges are required to be registered and reporting institution under BMM legislation, and BMM also treat them as digital currency. No official position from other statutory bodies yet. Philippines and Thailand Philippines has actually published rule for ICOs regulations, and also Thailand has enacted laws to regulate ICOs. And for Singapore, they have come up with fintech regulatory sandbox with ICO guidelines. I'll explain the position in this country in the next few slides. Overall, for Indonesia, despite crackdowns in the past and the reluctance of Bank Indonesia to accept them as legitimate means of payment, cryptocurrency have in the end received a recognition from the executive power. Means the Future and Exchange Supervisory Board had decided that they can be subject to future tradings, which means they will be regarded as commodities. But there is no official endorsement by the legislator in Indonesia. They still ban ICO, means that you still can't launch ICO in Indonesia. In Malaysia, BNN and SC have issued a cautionary statement in January 2018. Basically, they say that existing securities law apply. So if you are conducting or undertaking any securities offering, you will still need to register with SC and you still need to comply with the securities law in Malaysia, which is the CMSA. Exchanges are not formally regulated. I also want to highlight that tokens which are not capital market structures at this moment are not regulated, or yet to be regulated in Malaysia. In other words, if you structure the tokens as a utility token, it's technically not subject to the securities law in Malaysia. And so far, for accounting and tax treatments are also largely undetermined. There is no authority on whether the gains from sales of a utility token or security token is a capital in nature or revenue, or how to determine the income tax, RPGT, withholding tax, and SST. That's the position in Malaysia. And this slide also shows the considerations that issuers will need to take into account if you want to launch ICO in Malaysia or in any other jurisdiction, because the authority are pretty similar in these regions. If you launch an ICO in Malaysia, for example, then you will need to consider anti-money laundering legislation, and also whether your tokens are securities or utility tokens, and whether your tokens will be subjected to taxation. You also need to consider whether the statement made in the white paper are correct and accurate. Otherwise, there could be potential liability of thought of misleading or deceptive conduct. This slide shows CIS, collective investment scheme. There are a few elements which, if all these elements met, then it will be construed as collective investment scheme or investment scheme. These expectations, pooling, reliance, and control. If the holder of the token is led to expect profit, rent, or interest arising from the asset or business that is funded by the token, then this expectation elements is met. There's poolings of contribution from investors. In a typical ICO, the investor contribute Bitcoin or Ether. This can be construed as meeting this element as well. Reliance and controls are also typically met in a typical ICO process. This is ICO session is just to show that if you are doing an ICO, whether the tokens will meet the CIS definitions. If you look at expectation, it really depends on the structure of the tokens, but realistically speaking, most token holders buy tokens or invest tokens, they expect profits from their investment. That's why these expectations is met as well. Pooling, reliance, and control most of the times met as well. So a lot of the tokens in the market are actually collective investment scheme. We also foresee an inevitable evolution to security token, means a lot of the tokens in the market will be construed as security tokens, which need to comply with securities law. Next, we look at the Philippines market. Philippines SEC has published a set of draft ICO rules for the public review. It's very interesting development. Under the rules, it says that any company registered in the Philippines looking to run an ICO or any ICO selling tokens to Filipino must submit an initial assessment request to the SEC to determine whether or not their token is security. It's the approach taken by SEC that all the tokens are by default deemed as security unless you've proven otherwise. It's like the process. If you want to conduct an ICO in Philippines, you need to submit a form, an assessment request form to SEC to show them that whatever you are doing is complying with securities law. It is not security. It has to be backed by a legal opinion to show that your token is security, is utility token and not security token. And if so, then you are not subject to the prospectus registration requirement. In short, there is this economic zone which allows exchanges to be set up there, and also for ICO operator to issue tokens there. Next is Singapore. ICO are allowed in Singapore. MAS released guideline which states that tokens that are capital market product under the Security and Futures Act can be regulated. The guides outline six studies to identify whether the ICO falls within the definition of a capital market product. It's very similar to the definition in Malaysia under the CMSA. If it's regulated under the SFA as capital market product, then the issuer will have to comply with the local existing securities law. And MAS also has Singapore has also this new payment services bill, which require intermediaries that buy, sell, or exchange with virtual currencies to be approved or recognized by MAS. Thailand is the only country in Southeast Asia that has enacted laws to regulate ICOs, comprehensive regulatory frameworks for ICOs. It just came effective in July this year. Issuer who would like to conduct ICO must file the registration statement and draft prospectus with the SEC, and such offering must be carried out through an ICO portal. recognized by the SEC board. Some requirements. ICO issuers are also mandated to have a company registered in Thailand, approved by the SEC with a minimum registered capital of 5 million baht. There's some cut-out also if offering is made to institutional investors, venture capitals, and private equity firms, and ultra high net worth individual. Then the token cap value for retail investor is 300 baht. Disclosure of investment prospectus, financial statement, and the source code are all mandated by SEC. Operator of a digital asset business like exchanges must obtain an approval from the Minister of Finance and meet the SEC requirements. Other than requirement for ICOs, Thailand has also enacted laws to regulate the taxations of earnings from tradings of cryptocurrency. There's this withholding tax at a rate of 15%. It works very similarly to a capital gain tax. If you gain from the trading of cryptocurrency, the gain will be subject to a 15% tax, in addition to your personal income tax, which is taxed at a progressive rate of 5% to 35%. There is also a value-added tax, like GST, for a rate of 7%. To give a summary of the regulatory position in Southeast Asia, Thailand and Philippines, there are new regulatory frameworks for ICO and digital asset businesses. The framework seeks to protect investors, encourage innovation, and promote investment from institutional and accredited investors. For Singapore, yes, the government has issued guides on ICO, but not a whole new set of regulatory framework for ICO and digital asset businesses. It means that existing securities laws do apply. For Malaysia, ST and BNM have issued a cautionary statement and evaluate ICO project on a case-by-case basis. Exchanges must still be registered with BNM as reporting institution. Existing securities laws still apply. As for Indonesia and Vietnam, still negative ban on crypto.